Welcome to the European Parliamentary Research Service podcasts.
The European Commission proposed a new regulation on the recognition of parenthood between EU countries to ensure that the parenthood established in one member state is recognised in all others. Want to know more? Stay with us.
An estimated 2 million children face problems when trying to have their parenthood recognised in another EU country. For example, when moving to another member state or returning to their home country. Now, why is that?
That's because jurisdiction and rules on parenthood fall within the scope of member states' private international law, and these diverge on issues such as the establishment of parenthood and on the recognition of parenthood established in another member state.
Under EU law, EU countries must recognise parenthood as established in another member state in the case of rights derived from EU law, in particular free movement, such as the right of entry and residence in another member state, the right to equal treatment, and the right to get travel documents for the child.
But EU law does not include the recognition of parenthood as established in another member state for the purposes of the rights derived from national law, such as tax and social benefits.
And while these issues are particularly common among rainbow families, they are equally troublesome for different-sex couples, where the recognition of parenthood is not always certain.
This uncertainty can be detrimental to children, discourage families from moving across countries, or push them to embark on long and costly legal proceedings. So, how does the EU want to make it easier for them?
In December 2022, as part of its equality package, the European Commission proposed a new regulation to harmonise national rules on the recognition of parenthood.
With it, the Commission wants to harmonise rules on international jurisdiction. That is, rules determining which member states' courts are competent to establish parenthood in cross-border situations.
The proposal also says that, as a rule, the law applicable to the establishment of parenthood should be that of the member state where the person giving birth lives, or otherwise, the country where the child is born.
Furthermore, court decisions and authentic instruments establishing parenthood issued in a member state should be automatically recognised in another. However, recognition of parenthood established in a non-EU country will still fall within the national law of each member state.
Now, one of the most interesting elements of the proposal is the creation of a European Certificate of Parenthood. This covers the recognition of parenthood of all children born in the EU, irrespective of how they were conceived or born, their type of family, and of the nationality of both child and parents.
And this includes the recognition of the parenthood of children with two same-sex parents and children adopted domestically in a member state by one or two parents. The European Court of Human Rights in Strasbourg has also dealt with many cases concerning recognition of parenthood, mainly concerning adoption and surrogacy. Here's Dr. David de Groot from the European Parliamentary Research Service.
The case law of the European Court of Human Rights concerns cases where parenthood is not recognized on the basis of private international law. In such cases, the state that refused to recognize then has to devise a procedure under national law, in its family law, to create a family link, like through adoption, for example. The proposed regulation would avoid such a procedure from being necessary between EU countries, since recognition should already be possible on the basis of private international law.
Now, how will children and parents benefit from the proposed new legal framework? Stay with us.
If the proposal goes through, it will strengthen the protection of the rights of children in cross-border situations within the EU, give both parents and children more legal certainty and predictability about the rules that member states must apply when establishing the parenthood of a child in a cross-border situation. It will also reduce the legal costs and burden for families and national judicial systems in connection with proceedings for the recognition of parenthood in another member state.
But it is far from certain that the proposal, in its current version, will be approved, as it is going to be adopted in a special legislative procedure without trilogue negotiations between the European institutions. Instead, it must be adopted unanimously by the Council after consultation with the Parliament. We spoke to the Parliament's rapporteur, Maria Manuel Leitão Marques.
Currently, a family might be subject to different laws in different member states to determine the parenthood of a child. This means that a child may lose their parents, legally speaking, of course, when they enter in another member state. This proposal will assure that once a parenthood relation is established in a member state, it is recognized in all of them.
So, how have stakeholders and legal experts received the proposal?
Representatives of LGBTI groups have welcomed the proposal as a major step forward in ensuring equal protection for all children, regardless of the type of family they are born in.
In a study commissioned by the European Parliament, Dr. Alina Trifonidou considered that EU institutions should not amend the instrument in order to exclude surrogate-born children from its scope.
There are 3 reasons why surrogate-born children should not be excluded from the proposal. First, because they are one of the groups of children disproportionately affected by non-recognition and are thus in most need of protection. Second, because their exclusion from the instrument would amount to discrimination based on birth. And third, because the ECHR requires already the recognition of the parenthood of such children in some circumstances, and thus EU law should be read as offering at least equivalent protection.
She also believes the Commission should extend the territorial scope of application of the proposed regulation to situations where parenthood was established in a third state.
Want to know more? Check out Dr. David de Groot's full policy brief on the EPRS website or in our app.
This is a European Parliamentary Research Service podcast.
Thanks for listening.